there are a couple of new changes in the way the Residential Act is set up. You know, it provides that the provisions apply to occupancy in all single-family, multifamily, residential dwelling units and multifamily dwelling units located in the Commonwealth. Like the code before, with some slight changes, it has, kind of a definition of things that sound like they might be residential in nature, but they're not by code. So, this would be, rent-to-own arrangements, fraternity houses, hotels, motels, temporary employment, 60 days or less, commercial, business, agriculture, obviously, a tenant who pays no rent, campground occupancy. And one of the things that, that used to be an exception was that where you had I'll say a small investor who owned a single-family residence located in Virginia, was natural persons or their estates, they owned it in their name and no more than 2 single-family residences, subject to a rental agreement, they could actually put in the residential rental agreement that they elected to opt out, and they could opt out of the Residential Act. And why would you do that? Because as an owner, there are a lot more safeguards for tenants and a lot more obligations for landlords. And so there was some practical reasons that you might not want to be governed by the Residential Act if you didn't have to be. These exceptions were not continued. And so what's interesting is that the language actually says it applies in all jurisdictions and may not be waived or otherwise modified in whole or in part by localities, by boards, by commissions, or by the courts. So the General Assembly has made it clear that if it is a residential tenancy and it's not accepted by the items we just looked at, you can't opt out of it. It governs you. End of story.